UK major update after government's visa move, skilled workers pushback. It started with a letter, not a visa approval, not a rejection, a policy notice, the kind that governments send out when they've already made the decision and they're simply informing you that your future has been restructured. A quiet inbox notification. A updated immigration rules document published on a government website at a time when most people were asleep. A PDF that didn't shout, but landed like a hammer. And across the United Kingdom, in NHS hospitals in Manchester, in tech offices in London, in care homes in Birmingham and Edinburgh, phones started lighting up. This update didn't take years to arrive. It arrived overnight. Overnight that could freeze a visa renewal you were counting on. Overnight that could close a route that brought you to this country in the first place. Overnight that could separate a family that had finally started to feel settled. One wrong assumption here, and you could be preparing to leave a country you have called home for years. What the UK government announced crossed a threshold that skilled workers, their unions, their employers, and their immigration attorneys had warned would trigger consequences. And when that threshold was crossed, skilled workers did not stay silent. They responded with urgency, with legal challenge, and with a collective pushback that is now reshaping the conversation in Westminster. Most people in this situation make the same mistake. They read the headline, they panic, they either freeze and do nothing, or they act impulsively without understanding the full legal picture. Today, you are going to do something different. For months now, there had been signals, not from the Home Office's official press releases, not from formal parliamentary readings, just signals, that the UK government was preparing something significant for the skilled worker visa category. The net migration figures had dominated the political headlines. Ministers had been under pressure from multiple directions, from opposition parties, from backbench MPs, from tabloid campaigns demanding tighter controls. The government had been measured, yes, but also increasingly aggressive in the way it approached that narrative. Their statements followed a pattern, a tightening pattern, a restricting pattern, almost a deliberate compression pattern. But what triggered real concern inside immigration law firms and skilled worker advocacy groups this season was that the usual pre-announcement consultation signals went completely silent. No open policy consultations, no leaked committee discussions, no informal briefings to sector groups. Immigration attorneys who monitor UK visas and immigration activity recognized what that silence meant. The sudden absence of stakeholder engagement, the removal of routine guidance updates that typically precede rule changes. The unusual speed with which internal Home Office statements shifted from vague to operational, the quiet restructuring of the points-based system threshold language. And when the UK government goes silent before a migration announcement, it means the decision has already been made, and the announcement is just the formality. Early this year, the Home Office published what senior immigration analysts described as a sweeping revision to the skilled worker visa framework, including salary threshold increases and occupation list adjustments not seen in over a decade of points-based system management. These are moves the government only makes when signaling something specific: a long-term structural reduction in inbound skilled migration, a recalibration of which sectors qualify for sponsored worker routes, or a direct political response to net migration numbers that have become a liability at the ballot box. Observers weren't immediately certain which of those drivers was primary, or whether all three were operating simultaneously. But one thing was unmistakable. The UK government was changing its posture towards skilled worker immigration in a way that would have immediate, measurable consequences for hundreds of thousands of workers and their families. And when that happens with minimal consultation, every immigration attorney, every sector employer, and every affected worker pays close attention. The policy move issued by the Home Office in this cycle was not routine administrative housekeeping. It was not a minor technical amendment buried in an appendix. It was structural. Sector representative after sector representative, briefing after briefing, with employers and unions, described the shift as disruptive, far-reaching, and most critically, retroactively threatening to workers already in the UK on existing skilled worker visas who were approaching renewal under the new, higher salary thresholds. But policy only achieves its intended effect if the people affected accept it without challenge. Skilled workers did not. Their collective response, through legal advocacy, employer coalitions, and parliamentary lobbying, has been among the most organized and sustained pushbacks the UK immigration system has witnessed from a non-asylum worker population in recent years. This week, multiple sources confirmed that skilled worker advocacy groups, backed by major sector employers, launched coordinated formal challenges targeting the new salary threshold requirements, including specific threshold levels in care work and hospitality that had recently been moved above what analysts believe was was the realistic market rate for those roles, specifically designed to reduce demand from overseas workers in those sectors. They moved before the full implementation deadline could lock the new rules in place. They challenged the salary floor for care workers. They challenged the removal of certain occupation codes from the shortage occupation list. They challenged the derivative impact on dependent visa holders connected to primary skilled worker applications. This was not symbolic protest. It was legally and operationally targeted. And that is precisely what made the government's policy move so consequential, because it provoked exactly the kind of organized resistance that now has the potential to force amendments. Let me break down exactly what changed, because if you are on a skilled worker visa in the UK right now, or you are waiting on a sponsorship offer, this directly affects your planning. The UK's skilled worker visa operates under a points-based framework introduced after Brexit. It requires a job offer from a licensed sponsor, a minimum skill level, and a salary that meets a defined threshold. For years, that salary threshold sat at levels that reflected the lower end of median wages for qualifying roles. What the government has now done is raise that threshold significantly, citing inflation, wage growth data, and a political commitment to reduce reliance on overseas labor in sectors the government believes should be filled domestically. The general salary threshold for most skilled worker routes has increased. The shortage occupation list, which previously allowed certain roles to qualify at a discounted salary rate, has been substantially overhauled, with many roles removed from the discounted tier. And crucially, the new thresholds apply not just to new applications, they apply to renewal applications as well. That last point is the one causing the most alarm inside the skilled worker community right now. I want to be direct about who is most affected here, because this is not a single profile issue. NHS workers, particularly nurses, allied health professionals, and social care staff recruited internationally over the past several years, are among the most immediately impacted groups. Many of these workers were brought to the UK specifically because domestic supply could not meet the healthcare sector's demand. They were offered salaries that met the threshold at the time of their original visa issuance. Those same salaries may now fall below the new renewal threshold, meaning workers who did nothing wrong, who have served their employers and their communities faithfully, now face a renewal process that is materially harder than the process that brought them here. The care sector is facing a particularly acute version of this crisis. UK care homes and home care agencies rely heavily on international recruitment. The workers they hired under the previous threshold structure are now caught between employers who cannot immediately raise wages to the new levels and a government that is not offering transitional protections. The technology sector is also watching this closely, particularly mid-level software engineers and data professionals who were brought in under sponsorship arrangements where the salary was competitive at the time but may need recalibration against the new threshold. There is a legal dimension to this situation that most mainstream coverage is not discussing clearly enough. Several immigration law firms have already filed judicial review applications challenging specific aspects of the threshold change, particularly its retrospective application to renewal cases. The legal argument centers on the concept of legitimate expectation, the principle in UK public law that where a government policy creates a reasonable expectation that a person can rely on, changing that policy in a way that damages the person who relied on it requires procedurally fair handling and, in some cases, compensation or transitional relief. The courts have not yet ruled on these applications, but the legal community is watching closely. A successful judicial review challenge could force the Home Office to introduce transitional arrangements for workers already in the UK on existing visas, buying time and legal breathing room for tens of thousands of renewal cases. An unsuccessful challenge would confirm that the government has broad discretion to restructure salary thresholds, even when doing so catches existing visa holders in a position they could not have anticipated at the time of their original application. I also want to address the political environment around this decision because it matters for understanding what comes next. The UK government is not operating in a vacuum. Net migration to the United Kingdom hit record levels in the years following Brexit and the COVID-19 pandemic. Those numbers became a significant political liability for the previous government and remain a defining issue for the current one. The political pressure to demonstrate control over immigration numbers has pushed policy in a direction that many economists, employers, and sector unions argue is economically counterproductive. The NHS cannot fill its own vacancies domestically. The care sector is facing a structural workforce shortage that domestic recruitment alone cannot resolve. The tech sector competes globally for talent that has other English-speaking destinations to choose from. Raising salary thresholds reduces inbound numbers, which satisfies the political narrative. But it also risks understaffing critical sectors, reducing employer competitiveness, and creating a humanitarian problem for workers already in the country who are caught by changes they had no ability to prepare for. That tension between political optics and economic reality is exactly what is fueling the skilled worker pushback happening right now. Let me now tell you what you should actually be doing if you are a skilled worker in the UK or planning to apply for a skilled worker visa. First, if you are currently on a skilled worker visa and approaching renewal, you need to check your current salary against the new threshold immediately. Do not wait for your employer to flag this. Check it yourself. Pull up the current Home Office guidance on skilled worker salary requirements and compare your salary to the new general threshold for your occupation code. If your salary falls below the new threshold, you need to open a conversation with your employer now, not 3 months before your renewal date. The earlier you identify the gap, the more options exist for addressing it before it becomes a visa problem. Second, if your occupation is on the immigration salary list, check whether your specific role still qualifies for any salary discount. The shortage occupation list has been replaced with a revised immigration salary list that applies different rules. What applied to your occupation 6 months ago may not apply today. Third, if you are a care worker or healthcare support worker on a health and care visa, there are sector-specific rules and recent changes that affect your route directly. The health and care visa remains a distinct pathway, but it has also been subject to restriction measures this year. Make sure your sponsoring employer remains a licensed sponsor and that your employer category still falls within the qualifying health and care employer list. Fourth, at imenasimio, onenien, melsminabain, boilestando, reim. If you are outside the UK and planning to apply for a skilled worker visa under a sponsorship offer you received before the threshold changes, confirm with your prospective employer that the salary on your certificate of sponsorship meets the current threshold, not the threshold that was in place when the offer was made. Salary thresholds at the point of application govern the outcome, not the threshold at the time the offer was extended. Fifth, do not attempt to navigate a renewal or new application under the new rules without qualified immigration advice if your case has any complexity. The cost of a solicitor consultation is vastly smaller than the cost of a refused application and the removal action that can follow. There is one more thing I want to say that I think goes beyond the procedural. Because this situation is not just an immigration story. It is a story about the kind of contract a country makes with the people it invites in. When the UK government actively recruited nurses from the Philippines, care workers from Nigeria and India, engineers from Eastern Europe and South Asia, it made an implicit agreement. Come here, work here, build a life here. And now, with salary thresholds being raised in ways that catch existing workers, not just future applicants, the terms of that agreement are being changed after people have already organized their lives around them. I am not saying the government has no right to change immigration policy. It absolutely does. But there is a difference between managing future inflows through forward-looking policy and retroactively destabilizing the lives of people who made decisions based on the rules that existed when they made them. The skilled worker pushback happening right now is not a political movement. It is a community of people, nurses, engineers, care professionals, teachers, defending the reasonable expectations they were given when they accepted an invitation that this country extended. That is a story that deserves to be told clearly and honestly. As this policy cycle continues, more legal challenges will be filed, more employer groups will submit formal representations to the Home Office, and more details will emerge about whether the government will introduce any transitional protection for workers already in the UK caught by the new thresholds. But one thing is already clear. Understanding your rights inside the UK immigration system does not make you a problem. It makes you prepared. It means you can respond to changes before they become crises. It means you can protect yourself, your visa status, and your family's future in this country. Share this video with every skilled worker you know in the United Kingdom. It might be the information that protects their case at exactly the right moment. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.